The Supreme Court chamber was a crucible of silence as Justice Amy Coney Barrett's gavel struck the polished mahogany bench, its echo reverberating through the hallowed room. Her voice, sharp and resolute, sliced through the charged atmosphere. Representative Crockett, this court finds your public statements regarding our recent decision profoundly troubling. You stand on the precipice of contempt. U.S. Representative Jasmine Crockett, a 44-year-old Democrat from Texas's 30th District, stood unwavering at the lectern, her eyes meeting the gazes of the 9 justices who held her fate in their hands. As one of the youngest African-American women in Congress, Crockett was no stranger to high-stakes battles, but this moment, facing potential contempt charges from the nation's highest court, was unprecedented. Barrett's tone remained stern, her words deliberate. You have 7 days to retract your statements and issue a public apology, or this court will be compelled to refer this matter for criminal prosecution. A murmur rippled through the gallery. Reporters' fingers flew across their devices, capturing every word. Yet Crockett, far from cowed, reached calmly for a sleek black binder on the lectern. Justice Barrett, she said, her voice steady and resonant, I've prepared a 20-page legal memorandum outlining why my statements are not only constitutionally protected but legally sound. What unfolded next would electrify the courtroom, captivate the nation, and redefine the boundaries of free speech and judicial authority. Before we dive into this historic constitutional clash, consider subscribing to our channel and sharing your thoughts in the comments on the delicate balance between congressional speech and judicial respect. Justice Amy Coney Barrett, appointed to the Supreme Court in 2020 at age 48, had cemented her reputation as a formidable jurist. Her incisive legal mind, honed as a Notre Dame law professor, and her unflappable demeanor made her a pivotal figure on the court's conservative wing. Barrett was particularly sensitive to public criticism that she viewed as undermining the judiciary's integrity, a stance rooted in her deep commitment to constitutional fidelity. Representative Jasmine Crockett, by contrast, was a rising star in American politics. Elected to Congress in 2022, she brought a fiery eloquence and unyielding advocacy for justice to Capitol Hill. A former public defender and civil rights attorney, Crockett had graduated from the University of Houston Law Center, where she excelled in constitutional law. Her legal acumen, often overshadowed by her passionate oratory, was about to take center stage. The conflict had erupted 3 weeks earlier, sparked by the Supreme Court's divisive 5-4 ruling in Thompson v. Department of Justice, which curtailed federal authority over state criminal justice reforms. During a fiery speech on the House floor, Crockett had declared, "This decision is a constitutional misstep, rooted in a flawed interpretation of precedent and an overreach of judicial power. The majority opinion sidesteps decades of settled law to prioritize ideology over principle." Her remarks, bolder than typical congressional critiques, ignited a firestorm. Legal scholars debated whether Crockett's words crossed into contempt, while conservative pundits demanded accountability and progressive voices championed her right to dissent. The stakes were monumental. A contempt finding could derail Crockett's congressional career and even lead to imprisonment. For the court, led by Barrett, the case tested its authority in an era of eroding institutional trust. For Congress, it raised the question of whether elected officials could challenge judicial decisions without fear of retribution. The court's extraordinary summons for Crockett to appear in person before all 9 justices had no modern precedent. The Washington Post called it a constitutional showdown for the ages, while the Wall Street Journal framed it as a clash between legislative free speech and judicial prerogative. As Crockett stood in the chamber, the gravity of the moment was palpable. Her legal team had urged her to apologize immediately, drafting a conciliatory statement. House leadership, wary of escalating tensions, had advised moderation. But Crockett, drawing on her years as a trial attorney, had spent sleepless nights poring over Supreme Court precedents, free speech doctrines, and historical executive judicial disputes. Her research had solidified her resolve to take a daring path, one that could either vindicate her or end her career in spectacular fashion. Now, as Barrett issued the 7-day ultimatum, the confrontation reached its zenith. The gallery braced for Crockett's response, expecting a retreat. Instead, she opened her binder with deliberate calm. Justice Barrett's brow furrowed as Crockett began. Justice Barrett, before the court proceeds, I respectfully submit that my statements fall squarely within the protections of the First Amendment and the Speech or Debate Clause. Chief Justice Roberts leaned forward, his curiosity piqued. Justice Sotomayor adjusted her glasses, her interest evident. Representative Crockett, Barrett said, her voice tinged with caution. This is not a forum for debate. The court has made its position clear. Crockett nodded respectfully. I understand, Your Honor. However, I believe it is my duty to clarify the legal foundation of my statements to ensure the court's decision is fully informed. Barrett's eyes narrowed, but she gestured for Crockett to continue. Proceed. But know that your words here will influence our final determination. With that, Crockett launched into a meticulously crafted defense, her voice carrying the confidence of a seasoned litigator. Thank you, Your Honor. I'd like to begin with Bridges v. California, 1941, where this court held that criticism of judicial decisions, even if pointed, is protected by the First Amendment unless it poses a clear and present danger to the administration of justice. My remarks, while critical, posed no such threat. Justice Alito interjected, his tone skeptical. Representative Crockett, you accuse the court of prioritizing ideology over principle. That suggests bad faith, not mere criticism. Crockett turned to Alito, unfazed. Justice Alito, in New York Times v. Sullivan, 1964, this court protected robust debate on public issues, including sharp critiques of public officials, judges included. The court emphasized that such speech, even if vehement, is essential to democracy. She flipped to another page. Moreover, in Craig v. Harney, 1947, this court upheld the right to criticize judicial decisions, stating that what transpires in the courtroom is public property and that judges must endure scrutiny in a hardy climate. The chamber grew still as Crockett continued, her arguments weaving a tapestry of precedent. Justice Barrett, you raise the issue of my position as a public official. I'd like to address that directly with Garrison v. Louisiana, 1964, where this court protected a district attorney's critical comments about judges as essential to self-government. My role as a congresswoman, speaking on a matter of national concern, places my remarks within this protected sphere. Justice Kagan leaned forward. Representative Crockett, your knowledge of case law is impressive, but suggesting the court overreached implies deliberate misconduct. How do you reconcile that with respect for this institution? Crockett nodded, anticipating the question. Justice Kagan, in Wood v. Georgia, 1962, this court protected a sheriff's accusations of judicial bias, noting that elected officials must be free to speak on public issues. My critique focused on legal reasoning, not personal integrity. Barrett's expression softened slightly, though her scrutiny remained intense. Representative Crockett, you cite cases involving private citizens or local officials. A member of Congress speaking on the House floor carries unique weight. How do you address that distinction? Crockett seized the opening. Justice Barrett, the Speech or Debate Clause of Article 1, Section 6, explicitly protects congressional speech. In Gravel v. United States, 1972, this court affirmed that legislators' statements on public matters are shielded from external sanction, including judicial scrutiny. The gallery was transfixed. Reporters, expecting a reprimand, were now witnessing a constitutional masterclass. Crockett's command of precedent was astonishing, her arguments delivered with the precision of a seasoned advocate. Justice Thomas, typically silent, spoke up. Representative Crockett, your statements could erode public trust in the judiciary. How do you justify that risk? Crockett turned to Thomas, her tone respectful but firm. Justice Thomas in Landmark Communications v. Virginia, 1978. This court held that protecting official reputation is not a sufficient basis to restrict speech. The public's right to debate judicial decisions outweighs the risk of discomfort to the judiciary. The chamber fell silent, the weight of her words sinking in. Barrett, recalibrating, posed a final challenge. Representative Crockett, are you arguing there are no limits to how elected officials may critique this court? Crockett shook her head. Not at all, Justice Barrett. Direct incitement to defy court orders, as in Bridges, would cross the line. But my critique of legal reasoning falls well within protected speech, as affirmed by this court's own precedents. As Crockett continued, citing cases like Texas v. Johnson, 1989, and Lane v. Franks, 2014, the proceeding transformed from a disciplinary hearing into a profound constitutional dialogue. Her binder, filled with highlighted cases and handwritten notes, became a symbol of her preparation and resolve. The justices, initially poised to reprimand, were now visibly engaged, some jotting notes, others exchanging glances. Crockett, then, delivered a striking historical parallel. This court has weathered far stronger criticism without resorting to contempt. President Lincoln challenged Dred Scott in 1861. President Obama critiqued Citizens United in 2010 before this very court. My remarks, by comparison, are measured and grounded in legal analysis, Justice Sotomayor interjected. Those were presidents, Representative Crockett. Your role as a legislator is distinct. Crockett nodded. Respectfully, Justice Sotomayor, the speech or debate clause makes no such distinction. Historical. Examples, from Senator Charles Sumner's critiques of the court in the 1850s to Representative John Lewis's in 2016, show legislators have long exercised this right without sanction. The chamber's atmosphere had shifted entirely. What began as a confrontation was now a substantive debate, with Crockett holding her own against the nation's highest legal minds. She closed with a nod to Barrett's own scholarship. Justice Barrett, in your 2020 lecture at Hillsdale College, you stated, the judiciary thrives when its decisions are debated openly, not silenced. I believe my remarks align with that principle. The silence that followed was profound. Barrett's own words, quoted with precision, hung in the air. Chief Justice Roberts cleared his throat. Representative Crockett, your arguments are noted. The court will take this matter under advisement and issue a ruling within 48 hours. This proceeding is adjourned. As the justices filed out, the gallery erupted in hushed excitement. Legal analysts scrambled to process what they had witnessed. A congresswoman, armed with a binder and a mastery of constitutional law, had turned a contempt hearing into a landmark defense of free speech. As Representative Jasmine Crockett stepped out of the Supreme Court building, she was engulfed by a swarm of reporters, their microphones thrusting forward like lances. Camera flashes lit up the marble steps, and shouted questions overlapped, in a chaotic symphony. Crockett, her binder tucked under her arm, raised a hand for calm. I've presented my case to the court, she said, her voice steady despite the frenzy. Out of respect for their deliberative process, I'll withhold further comment until their ruling is issued. Her measured response, delivered with the poise of a seasoned advocate, only amplified the magnitude of what had transpired inside. Within minutes, the nation was ablaze with analysis. On MSNBC, legal analyst Ari Melber broke down the hearing with palpable excitement. What we saw today was extraordinary. Representative Crockett didn't just defend herself, she delivered a constitutional law seminar to the Supreme Court, citing their own precedents with surgical precision. At Fox News, former Judge Andrew Napolitano offered a rare nod of approval. Agree or disagree with her critique, Crockett's legal defense was a masterclass. She's raised questions the court can't dismiss lightly. Social media erupted, with Freixer Crockett vs. Court and Constitutional Queen trending nationwide. Law students live-tweeted the hearing, marveling at Crockett's command of cases like Bridges v. California and New York Times v. Sullivan. A viral TikTok video featuring a young black woman reenacting Crockett's arguments with a mock gavel garnered 2 million views in hours. This is what representation looks like, the caption read. Behind the scenes, a lesser-known facet of Crockett's background came into focus. While her congressional biography highlighted her work as a public defender, few knew she had completed an advanced constitutional law certificate program during her early legal career, studying under renowned scholars at Howard University's law school. The Dallas Morning News rushed out a profile. Jasmine Crockett, the congresswoman who outmaneuvered the Supreme Court. It revealed her 4.0 GPA in her certificate program and a professor's recollection. Jasmine could dissect a Supreme Court opinion like a surgeon and argue its implications with unmatched clarity. Inside the Capitol, the mood shifted from anxiety to awe. House colleagues who had urged Crockett to apologize now gathered in Speaker Emerita Nancy Pelosi's office, watching pundits praise her performance. "She didn't tell us she was planning this," one senior aide admitted. "We had a retraction speech ready. Nobody expected her to walk in with a 20-page legal brief." House Speaker Hakeem Jeffries called Crockett personally. According to sources, he said, "You've made history, Jasmine. Win or lose, you've shown what fearless leadership looks like." Meanwhile, in the Supreme Court's private chambers, an urgent conference unfolded. The justices, accustomed to routine deliberations, faced an unexpected challenge. According to a clerk who later spoke anonymously to The New Yorker, Justice Barrett opened the discussion with candor. "We summoned Representative Crockett expecting a straightforward proceeding. Instead, she's presented a compelling First Amendment and speech or debate clause defense that demands our serious consideration." Justice Kagan reportedly added, "Her legal acumen caught us off guard, but it's undeniable. She's turned this into a constitutional referendum." The justices grappled with a dilemma: pursue contempt and risk validating Crockett's argument that the court was overreaching, or retreat and potentially signal weakness in defending judicial authority. Justice Gorsuch, typically reserved, noted, "Her citation of Gravel v. United States was spot on. The speech or debate clause complicates any contempt finding." Even Justice Thomas, skeptical of Crockett's tone, acknowledged her precedents were impeccably researched. Across the country, law schools scrambled to adapt. Yale Law announced a seminar, Congressional Speech and Judicial Power, Lessons from Crockett, while Stanford hosted a live-streamed panel with former clerks dissecting her arguments. The Harvard Law Review's online forum published an essay, Crockett's Gambit, Redefining Legislative Free Speech, arguing that her defense could set a new standard for protecting elected officials' critiques of the judiciary. Public reaction was equally fervent. Young women, particularly women of color, flooded social media with tributes to Crockett's poise and intellect. A viral tweet from a Dallas high schooler read, "Rep. Crockett just showed me I can be a lawyer, a leader, and a history maker." Black excellence. Conservative commentators, while critical of her original remarks, conceded her legal prowess. National Review's Ed Whelan wrote, "Crockett's defense was a bold, if provocative, reminder that constitutional debate isn't confined to courtrooms." 48 hours later, the Supreme Court issued its ruling. In a rare 9-0 decision, the court declined to pursue contempt charges. The brief opinion, authored by Chief Justice Roberts, acknowledged the significant constitutional issues raised by Representative Crockett's arguments and reaffirmed the robust protections for speech on public matters, including by elected officials. Justice Barrett penned a concurrence that would be studied for decades. "The judiciary's authority does not extend to silencing legitimate criticism," she wrote. Representative Crockett's presentation, grounded in this court's own precedents, underscores that open debate strengthens our constitutional framework. A republic that cannot withstand scrutiny of its courts risks fragility. The ruling was a triumph for Crockett, not merely a personal victory, but a landmark affirmation of legislative free speech. Legal historians would later call it a pivotal moment in defining the balance between Congress and the judiciary. At her next House floor speech, Crockett addressed the ruling with characteristic grace. "I am grateful to the court for engaging with the constitutional principles at stake. My respect for this institution is unwavering, but so is my commitment to speaking truth to power." The ripple effects were profound. Law school applications surged, particularly among Black and Hispanic students inspired by Crockett's example. Constitutional law courses saw record enrollment, with professors noting a spike in interest in the speech or debate clause and First Amendment protections. The relationship between Congress and the court subtly shifted, with future legislative critiques of judicial decisions becoming more precise, focusing on legal reasoning rather than motives, and the court responding with greater restraint. 3. Months later, Justice Barrett invited Crockett to deliver a guest lecture at Notre Dame Law School on legislative speech and judicial dialogue. The event, live-streamed to a global audience, sold out in minutes. In her introduction, Barrett reflected on their encounter. Representative Crockett reminded us that constitutional discourse thrives on rigorous debate, not silence. Her legal brilliance, rooted in preparation and principle, challenged us to uphold our own precedents. As Crockett took the podium to thunderous applause, her journey from potential contempt defendant to constitutional champion was complete. What began as an attempt to censure her had instead elevated her voice, reshaping the boundaries of free speech and legislative authority. The Congresswoman had proven herself not just a legislator, but a legal force, wielding the Constitution with precision and courage when it mattered most. The Notre Dame Law School auditorium buzzed with anticipation as Representative Jasmine Crockett stepped to the podium, her presence commanding even in the absence of a gavel. The audience, students, professors, and legal scholars from across the country hung on her every word. Justice Amy Coney Barrett, seated in the front row, offered a nod of respect, a silent acknowledgement of the extraordinary journey that had brought them from adversaries to collaborators in constitutional discourse. Crockett's lecture, titled "Speaking Truth, Defending Liberty," would become a touchstone for legal education, replayed in classrooms and cited in law review articles for years to come. Constitutional democracy thrives on debate, not deference, Crockett began, her voice carrying the same clarity that had stunned the Supreme Court. When I stood before the justices, I wasn't just defending my words, I was defending the right of every elected official, every citizen, to question and critique. The First Amendment and the Speech or Debate Clause are not mere privileges. They are the bedrock of our republic. She paused, her gaze sweeping the room. And as Justice Barrett has written, the judiciary's strength lies in its ability to withstand scrutiny, not suppress it. The lecture was more than a recounting of her Supreme Court showdown. It was a call to action. Crockett urged young lawyers to study the Constitution not as a relic, but as a living framework for justice. She shared anecdotes from her days as a public defender, where she learned to wield case law like a shield for the vulnerable, and from her congressional career, where she saw the power of speech to shape policy. The audience erupted in a standing ovation, with Barrett joining in, her applause a symbol of mutual respect forged through constitutional rigor. The event marked a turning point, not just for Crockett, but for the broader dialogue between branches of government. Her confrontation with the court had set a new precedent, both literal and figurative, for how elected officials could engage with judicial decisions. Legal scholars began referring to the Crockett Doctrine, a term encapsulating the robust protection of legislative speech under the First Amendment and the Speech or Debate Clause, particularly when critiquing the judiciary. Law journals published symposia exploring its implications, with titles like The Crockett Precedent Redefining, Congressional Free Speech, and Judicial Authority versus Legislative Voice, a post-Crockett analysis. In the months that followed, Crockett's influence rippled through American institutions. The Congressional Black Caucus launched a constitutional law fellowship in her name, aimed at training young attorneys of color in First Amendment advocacy. Law schools reported a 20% increase in applications from underrepresented groups, with many citing Crockett's performance as their inspiration. At the University of Houston Law Center, her alma mater, a new course, Constitutional Advocacy in Crisis, was added to the curriculum, using her Supreme Court brief as a core text. The Supreme Court itself was subtly transformed. Justices became more circumspect in responding to public criticism, mindful of the constitutional boundaries Crockett had illuminated. Barrett, in a rare public interview, reflected on the case. Representative Crockett's arguments forced us to confront our own precedents with fresh eyes. Her defense was a reminder that the Constitution belongs to all Americans, not just those in robes. The court's subsequent rulings on free speech cases, including a 2026 decision strengthening protections for public officials' commentary, bore the faint imprint of Crockett's stand. Politically, Crockett emerged as a national figure. Her name floated as a potential candidate for higher office. Yet she remained focused on her constituents in Dallas, channeling her newfound prominence into legislation on criminal justice reform and education equity, issues tied to the Thompson versus Department of Justice ruling that had sparked the controversy. At town halls, she spoke candidly about her Supreme Court experience, encouraging young people to study the law and engage in civic life. The Constitution isn't just for lawyers, she'd say. It's for anyone willing to stand up and speak out. The media, too, evolved in its coverage. Press secretaries and congressional spokespeople adopted Crockett's approach, framing critiques of judicial decisions in precise legal terms to avoid overstepping constitutional bounds. Cable news segments on court rulings now routinely included Constitutional Scholars, a nod to the public's heightened interest in legal analysis post-Crockett. The hashtag #Crockett vs. Court remained a fixture on social media, evolving into a platform for discussing judicial accountability and free speech. A year after the ruling, Crockett published a memoir, Voice of the Constitution, a Congresswoman's stand, which debuted at #1 on the New York Times bestseller list. The book detailed her preparation for the Supreme Court hearing, revealing late-night study sessions in her Capitol Hill office, surrounded by stacks of case law and notes scribbled on legal pads. It also offered a personal reflection on her identity as a black woman in politics, navigating spaces where her voice was often underestimated. I stood before the court not just as a congresswoman, but as a descendant of those who fought for the right to speak, she wrote. My defense was for them, too. The memoir's release coincided with a PBS documentary, Crockett's Court, A Constitutional Reckoning, which chronicled the hearing and its aftermath. Featuring interviews with legal experts, congressional colleagues, and even a rare comment from Chief Justice Roberts, the film cemented Crockett's place in legal history. Roberts, typically guarded, praised her preparation. Representative. Crockett's arguments were a testament to the power of informed dissent. On the second anniversary of the ruling, Crockett and Barrett reunited at a bipartisan constitutional law summit hosted by the National Constitution Center. Their joint panel, Dialogue Across Branches, drew thousands of attendees and millions of online viewers. The image of Crockett and Barrett, once opponents in a high-stakes legal battle, now discussing the Constitution with mutual admiration, became an enduring symbol of democratic resilience. We may disagree, Barrett said, during the panel, but disagreement, when grounded in principle, strengthens our system. Crockett nodded, adding, the Constitution demands courage to speak, to listen, and to learn. As the summit closed, Crockett received the Center's Liberty Medal for her contributions to constitutional discourse. In her acceptance speech, she quoted Frederick Douglass, "The life of the nation is secure only while the nation is honest, truthful, and virtuous." She continued, "Honesty means speaking truth to power, even when it's uncomfortable. Truthfulness means grounding our words in reason and law. And virtue means respecting the institutions we challenge, knowing they too are part of our democracy." The legacy of Jasmine Crockett's stand endured far beyond the Supreme Court chamber. It inspired a generation to engage with the Constitution, not as an abstract document, but as a tool for justice and accountability. It redefined the boundaries of legislative speech, ensuring that elected officials could critique judicial decisions without fear of retribution. And it proved that brilliance, courage, and principle could emerge from unexpected places, transforming a moment of crisis into a triumph for democracy. As Crockett returned to her Dallas district, she carried with her the quiet confidence of a woman who had faced the nation's highest court and prevailed, not through defiance but through the power of the Constitution itself. Her story, etched into legal history, would echo in courtrooms, classrooms, and capitals for generations, a reminder that the right to speak truth is the heart of a free society. If you found this account of Representative Jasmine Crockett's historic constitutional stand compelling, please like and subscribe for more in-depth legal and political analysis. Share your thoughts below on the balance between free speech and judicial authority, and hit the notification bell to stay updated on our latest content.